this resolution states that the act, the National Defense Authorization Act, violates certain provisions of the U.S. Constitution. What are those provisions? What is the current definition of treason? Have the question provision of the Act been determined to be unconstitutional? The first person that I'm going to call to the podium is Barnes Waltran von Schwarbeck, and I probably killed that, so, but from Linwood, Kansas. Okay.
The name is Walter von Schwarbeck.
Okay. And
I'm a native of Germany. Yes, continue please.
no, I was going to say that sometimes some of us have difficulty hearing. Okay. Go ahead.
Yes, sir. As you know now, I was not born here. I have this bloody accent. I was born in 1942 in Nazi Germany. And I remember my father teaching me very well what was going on. As I grew older, I had more understanding of it. And
1 minute, please. You know, as I'm thinking here, looking at the number of people that are going to testify, will somebody run a clock and let's limit the testimony to 5 minutes?
okay.
In that way, I think 5 minutes would be sufficient, and because I want to make sure everybody has an opportunity. I don't want anything to extend too long. Okay, so
I try to keep it brief.
please.
What concerns me mostly with my family's history and the tyranny of Hitler's Germany, I became a citizen, by the way, in the 70s. I moved over here with my first husband. He was a GI in the Vietnam era. And so I have been greatly concerned with the approval of the NDAA Act that Obama signed between Christmas and New Year. At first he said he wouldn't sign it, and then he did it anyway when everybody was celebrating and having a good time and starting the New Year and Christmas and all that. So this brings back things that my father warned me about, the absolute power of a government. And I was such a proud new citizen of this country in the 70s because I realized it was something very special that could not be found anywhere else in the world. And as I later found out, that was due, the prosperity of this country was due to the liberties that was given to individual citizens under the Constitution. And I guess the whole world was envious of what the Constitution provided for this country. And I understand a lot of countries base their Constitution also on ours. The Weimar Constitution in Germany was a very nice example. It provided quite a bit of freedom for the German citizen. It was similar to what the States has, but this was all changed as Hitler wanted to become dictator, and later it was found out that his propaganda minister was caught running away from the fire of the Reichstag, which is the Berlin parliamentary building, and so of the government then. So this enabled him in 1933. It was called the Enabling Act, which made him no longer just a chancellor. It made him a solemn dictator, and life in Germany changed drastically. Anybody that was not for it was declared an enemy. Also with this Reichstag fire, they created an enemy of the state, which were the communists, and they had to be rooted out, and it reminds me a lot of the broad application of the good Al-Qaeda and the bad Al-Qaeda that's floating around now here. You got to have an enemy so you can go out to war, and that's exactly what happened. And one draws in the other. After Hitler was made dictator, the witch hunt was on. Communists were on top of the list, and they became gypsies, Jews, etc. And as long as people weren't picked up, they felt safe. It was always the other guys that were picked up. So, curtailing freedom never brought any safety. Just like one of our founding fathers said, in order to bring in tyranny is for good people to do nothing. So I think this NDAA law, in my book, the way I read it, is unconstitutional and will bring nothing but heartache.
Okay, I'm not touching anything.
Next one is Dee Saddler.
Basically, what I'd like to share with you today is I see a progression of our legislation. It started out with the 2001 authorization, the AUMF, the authorization of the use of military force, which was there to protect us. That was the idea behind that bill. But what I see since that time is basically it went to the Patriot Act. And when you talk about the Patriot Act, as a response to the terrorist attacks of 9/11, this act dramatically reduced restrictions on the law enforcement agency's ability to search telephones, email communications, medical, financial, and other records. It eased restrictions on foreign intelligence gathering within the United States, expanded the Secretary of Treasury's authority to regulate financial transactions, particularly those involving foreign individuals and entities. And it broadened the discretion of law enforcement and immigration authorities in detaining and deporting immigrants suspected of terrorism-related acts. The act also expanded the definition of terrorism to include domestic terrorism, thus enlarging the number of activities in which the U.S. Patriot Act's expanded law enforcement powers can be applied. This was done at the expense of the First and Fourth Amendments, allowing warrantless searches, prohibiting citizens from crying out for help in defense of their Fourth Amendment rights, and more importantly, making it a crime to disclose their rights have been violated even to their spouses. I realize on May 26th of last year that the President Barack Obama went ahead and passed the bill to extend the Patriot Act, despite Rand Paul saying basically the Patriot Act is here to stay. Congress passed a 4-year extension on this controversial legislation, which allows continuation of the post-9/11 powers to conduct roving wiretaps in pursuit of terrorists. And this is where I see the shift. 2004, Hamdi versus Renfield. In this case at the court, I know many of you are familiar with this, reversed the dismissal of habeas corpus petition brought on behalf of Yasser Hamdi, a U.S. citizen being detained indefinitely as an illegally enemy combatant. The court recognized the power of the government to detain enemy combatants, but ruled that detainees who are U.S. citizens must have the ability to challenge their enemy combatant status before an impartial judge. Hamdi was detained without charge or trial for 2 years. 1 year he spent in Gitmo, or Guantanamo, and the second year in a brig in South Carolina, and this is a U.S. citizen. His habeas corpus petition was denied by the lower court, and the Supreme Court reversed this decision. Justice Scalia, who voted for the majority, wrote a dissenting opinion stating that the High Court itself had acted as Mr. Fix-It without addressing the legitimacy of the executive branch's constitutional authority. 2006, the Military Commissions Act. Senator John Warner negotiated with the White House the language of the Military Commissions Act of 2006, suspending habeas corpus provisions for anyone deemed by the executive branch to be an unlawful combatant, and barring them from challenging their detentions in court. Warner's vote gave a retroactive 9-year immunity to U.S. officials who authorized, ordered, or committed acts of torture and abuse, permitting the use of statements obtained through the torture to be used in military tribunals without regard to the citizens' constitutional rights. Warner's compromise authorized the President to establish permissible interrogation techniques and to interpret the meaning and application of the International Geneva Convention standards so long as the portion falls short of serious bodily and psychological harm. The law expanded the types of covered persons as either private belligerent or underprivileged enemy belligerent, and expanded the definition that qualifies as taking a direct part in hostilities beyond that recognized by the majority of international communities and Geneva Convention AP1. So basically at this point, I want a definition of the word belligerent, and that's what I see in this law. There's also a lot of ambiguity of the words. I think we need to take note of that. 2008, the North American Military Act. This is a military plan that designed to bypass Posse Comitatus Act that traditionally prohibited the U.S. from operating within the borders of the United States. Not only will American soldiers be deployed at the discretion of whoever is sitting in the Oval Office, but foreign soldiers will be deployed in American cities. Why? I guess that's my question, why? This showed the executive branch expansion of military power by bringing the foreign troops into the U.S. active assignment. This agreement was signed by the U.S. Air Force General and the commander of the Canadian Forces. 2009, Homeland Security releases a document called Right-Wing Extremism, Current Economic and Political Climate Fueling the Resurgence of Radicalization of Recruitment. This report profiles those who do not agree with our president. Is there anybody here who agrees with me, what he might say? Those who support our Second Amendment rights, those who oppose illegal aliens in the country, and disgruntled military veterans, as possible right-wing extremists who are hate-oriented and anti-government. So now the shift has taken place. We're not talking about terrorists anymore. Now we're talking about you and me. 2009, Missouri Information Act Analysis and Center. This is the DHS Fusion Center. Releases the modern militia movement. This report, patterned after the DHS report I just spoke of, is outlining the right-wing extremists in the militia. It characterizes constitutionalists. Yes. Can I wrap it up? Okay. Basically, I just wanted to point out that there is a progression in our legislation, and it's very much a concern to me. Just as the Baroness talked about what happened in Nazi Germany, we need to take a look at what happened. And I know when you're talking about NDAA, you're talking about one piece of legislation. And I just want you to look at the total picture. Thank you very much for your time.
Jill is here. Jill, do you have a little time to explain the paper? Or I don't know if you're ready to do that or not. Jill Shelley is from our research department, and she did a marvelous job with the help of all our research assistants to put this paper together, which I think goes into quite a bit of detail about the bottom line. So,
with your permission, Mr. Chairman, I'll just outline what's in the memorandum.
Please.
Because you had requested information in preparation for this hearing. So I started with what is the National Defense Authorization Act?
I explained before you came in all the questions that frame what we were doing here. So I explained all those questions already. Basically, I just wanted to say that this has gone into quite a bit of detail to addressing some of the issues. And I think, for example, Ms. Saddler might want to look at some of this paper, because I think it addresses some of the concerns that you have. Anyway, if you have a brief description, or you want to go into some details, you have the floor.
Well, I just wanted to point out that this memorandum includes the actual text that is being brought up in the resolution, so that the text is there for your examination and look at the words. I tried to find authoritative sources from organizations that I know to employ constitutional scholars. So those were my primary sources for any opinions that you find in this memorandum. And also, It does include a little bit of the background on the authorization for use of military force, and that very, very short bill is also the text of that is also provided for your perusal. It has a little bit about Humvee versus Rumsfeld, the particular quotations from that plurality opinion dealing with habeas corpus, that particular opinion. I also found that, again, I was just trying to provide a very brief overview, but there was a little bit from an international known scholar regarding the laws of war and what that says about detention, preemptive and on the battlefield. That's just a brief paragraph in there. The resolution specifies a certain number of amendments to the U.S. Constitution. I provided that exact wording for you so that you can look for that. And we also have direct quotes from the Kansas Bill of Rights, also related to those that are new. And then we have a section on the relationship between constitutional law and state employment, because that also is a portion of the resolution before you, and just some of the background on that. I'd be happy to try to answer questions.
Do we have any question to Ms. Shelley, committee? No questions, but I'm certain that by the end of the hearing, we probably will have some questions. Anyway, thank you. I'm going to call Jay Atkins from Burlington, Kansas.
My first question would be, would you want to substitute your time to let Dee finish her?
If somebody else needs it, yes, I'll.
And would the committee like to have Dee finish the progression of that first before I speak?
Would that be beneficial?
Even more important would be your copies.
I will make sure we make that
And
for you.
in my experience, okay, a lot of times we hear so much testimony that sometimes it's difficult. If we have the written testimony, then it's easier to go ahead and draw conclusions on the final product.
I absolutely understand.
So, anyway.
Yes. Thank you for having me up here. I'm going to start out by reading to you a letter to this committee from Representative Charles Key of Oklahoma. He introduced this resolution in their house. April 23rd, 2012. May it please Chairman Waco and the members of this honorable committee. I regret I am unable to appear in person to testify on a matter of such significance, but hope you will accept a statement in lieu of my personal
Actually, that letter was submitted to the committee by the representatives, so we all have it.
Okay,
So
you don't need me to read that?
no, sir, we have that letter. So
that will work. Excellent. Okay, then I will get to mine. On December 31st, 2011, Barack Obama signed into law the NDAA. Now, we do understand the National Defense Authorization Act provides for funding our military, our operations, our bases, so on and so forth. But embedded inside of this law is the sections 1021 and 1022. When you read those, it talks about how they're going to detain a terrorist or insurgent. And it also talks in there about the American citizen. When you speak to the structure of a paper in legalese, a lot of times that will define how this can be used. After they go through the detriments of it, then it says, oh, it won't be used against American citizens. It says in the congressional report, it won't be used against an American citizen. However, the federal government, as I'm sure we can all agree, has a tendency to push the limits of any law it ever passes, to try to get as much power and consolidate as much power as it can. the way this thing is structured will allow them to interpret to be used against an American citizen if they decide this person is guilty of treason or could be a terrorist. Now, this can come down to being as much when you put into context this next bill that's coming up on the Hill. I think it's this week. And the name of that, I think, is Protecting Children from Internet Pornographers Act of 2011. There's also one being submitted by Harry Reid, the Senate. It's a cybersecurity bill. Basically, in a nutshell, it allows the NSA or security components of the government to monitor your internet usage. They'll be able to look at the websites, the ISP addresses that you're using, and what you're looking at. And in the definitions of some of the NDA, if you decide, say, to research, such as I've worked with my representative, Peggy Mass, about Islam, to learn about it when we first started having the conflicts and things, to find out what it's about. If you decide to use your computer and go to an Al-Qaeda site to research what they're saying, and your ISP shows up on that red flag to the NSA, if they pass all this so they can monitor this, they can label you a terrorist and use the full force of, in the night, come and get you with a military escort to be taken to a place of detention, not allowed an attorney, not allowed to contact anyone until the time that this conflict is resolved. When is the conflict going to be resolved? You know, all of a sudden you just disappear in the night. It sounds a lot like Nazi Germany, I mean, some of the things that they pulled. Now, it's up to our legislators to block the federal government whenever they take steps to steal our God-given constitutionally secured rights. My 10-year-old daughter asked me before I came up here today to please ask you to step between the feds and her. She's watching this. The kids in school are watching some of this. And they're not scared of Al-Qaeda anymore. They're scared of the federal government. I talked to a man at a convenience store in Burlington, Kansas, where we have more cows in our county than people. And this guy admittedly said straight up to me, I'm afraid to say what I think in public. If I say this president is treasonous and he is bringing our republic down to the level of Syria, I am afraid if they hear that, they'll come get me. I never once in my life thought I would hear something like that. Growing up in the streets of Kansas in the county gate center, another county with more cows than people, walking down the street, never had a fear of a golden blowing up in my face. I never thought I would see the day that people would fear that in the United States. I still don't think we will see that in the United States. American people are vigilant. The American people have the Second Amendment if we're allowed to use it. And it's up to us to step up and say, we will use it. I will protect my family, my sheriff, and my peace officers, my highway patrolmen back here. They're all a great source of pride to me that I can call on them and yell help and they'll get there as quick as they can. But until they get there, it's my responsibility to protect my family. NDAA in this, it circumvents treason. But treason it's defined in the Constitution to take care of this kind of thing. It also removes the core value in American jurisprudence of innocent until proven guilty. You know, if they decide, oh, you're a terrorist because you went to the website.
It's 5 minutes. We will summarize. And we presented the preparer before you leave. I don't know if you want to address a group since she brought up. Do you want to address a group?
Yes, I have to go to another committee meeting.
You need it now?
I'm going to be in that committee meeting with you, actually. So,
Go ahead, I'll summarize.
Okay, thank you very much.
okay.
This is just extremely important for legislative body in the state of Kansas to say, we're going to draw a line in the sand and we're going to pass this resolution. We're going to tell the federal government we do not support this, and that we're going to stand up for the rights of the citizens in the state of Kansas. And you all know how states' rights have continually been eroded. And now we're getting down to the rights of individuals. And I just urge this committee to seriously consider this and pass it out favorably. So I stand for questions.
Any question for Representative O'Hara?
Just a quick one, Representative, thank you for being here. The main thing I'd like to know is, make sure it's, I'd like to know the differences between when Bush signed this and what the current president does. I have some of the same feelings you do, that are very untrustworthy of our current administration. Anyway, so if those are provided in either other details or some, then I would like to see that we're not overreacting, just acting on something that was passed in the past. That I'd like to see what some of those changes are and how that might affect our defense today.
I think that Dee Saddler has that.
Yeah, and I heard some of that's why I asked for the detailed reports that something I put my
right. And I'm
hands
also
on and trust.
certain that Richard Fry will be able to provide any specifics that you would like. You know, we all want to think, well, this isn't that bad. We can deal with this, but as our federal government continually approaches, we absolutely have to say no more. Obamacare is an excellent example. We have filed suit. We're now in the Supreme Court. It is just imperative on each individual state to be extremely vigilant as to what is happening. And we have such a huge mountain to get back what the states and individual rights are in this country. Our tax policy is confiscatory. We just, it's on and on and on. And it's because we have not had any courage, I think, at the state legislative level, to just say, no, we're not going to do this. We are going to stand for our rights as states and for our citizens.
Representative O'Hara. Just a point of clarification. I want to make sure everybody understands this. A resolution like this is no more than a statement from the House. It doesn't have any power.
Absolutely.
It doesn't do anything. I just want to make sure everybody understands what this will do.
It's a very small step, but at
Actually,
least,
a whisper, I think.
well, a whisper is better than nothing. It's a beginning, and a journey of 1,000 miles begins with one step. And so this is our first step, and then as we go forward, perhaps we can find more courage.
Thank you. And tell the committee that I'll be there as soon as I can, please. Okay, I'm going to call Larry Tawney. Oh, yes.
I would like to ask this committee to, as you said, this is a whisper, to consider moving this up a notch. We have Virginia has passed the anti-NDAA law. They will not allow any state resources to be used to implement this law. And they told the feds that they can't come in and do it. Arizona just passed one. It's going to the governor. And I will have to also say that although many tools that can be used to protect our citizens are good tools, we have technology that's great that can be used, but the potential of it to be abused and turned against our citizens is what we must be vigilant about. Even the TV cameras at the corner, that's something that can be used for good, but it could also be something, especially face recognition technologies. If they decide they don't like you, they could punch that in there, find out where you are committing tonight. So in summary, I ask you to please stand against the Fed and against the federal government. And thank you very much.
Okay, committee, do you have any questions for Mr. Connie? Thank you. I mean, Mr. Atkins, I wasn't this. Okay. Atkin.
Thank you folks for the privilege of being able to appear before you today. My name is Carl Atkin. I'm from Andover, Kansas. I'm a retired Wichita police officer. I've been in the field for 37 years. So perhaps I can give you a perspective on this that is relatively unique to each of you. And that is street cop, which is the best job in the world. Throughout my police career, I focused on serving and protecting. And I've done that diligently. And in doing that, I had to work within the confines of the Constitution, the United States Constitution, and the Constitution of the State of Kansas. Due process was something that I've engaged in and worked with. And I've heard some discussion concerning the NDAA, which, regardless, in my opinion, of who the originating president is a bad law. And it puts us on a slippery slope of a gradual erosion of the due process, especially search and seizure. And we know that laws, as they are passed now, are continually, or is it continuously, reinterpreted. They eventually go up to the Supreme Court, who gives the final interpretation as to whether that law is going to be enforced in a certain manner. And we all know that. We see it all the time. We wait diligently and with our breaths held for the Supreme Court to make the decisions on these, especially those in law enforcement. We're put in positions frequently of pushing the envelope on things, especially in search and seizure. The Fourth Amendment is clear about it, though. It deals with probable cause, which is the lifeline, the guiding principle of every police officer that puts a badge on and goes out to enforce the law and protect the citizens. Probable cause. And it's a relatively simple concept. I'm not going to engage in defining it for you here. But I would say that I've witnessed a couple of things that occurred in my lifetime and something that occurred prior to my being born in 1949. Japanese internment was a horrific example of what can happen to us when we permit due process to be overcome by overzealous people who are essentially trying to do what they believe to be the right thing. Now, I'm totally opposed to that type of philosophy. You know, the documentation, the documents of the Constitution is not a living, evolving document. Some of the interpretations may appear to be so. My interpretation is that it's not. Most recently, I had occasion to serve as a security guard in New Orleans, where I was afforded many opportunities to discuss the problems that occurred down there subsequent to Katrina smashing through and tearing the place up. Essentially, I was able to talk with some victims of gun confiscation without benefit of search warrants, without benefit of probable cause of crimes being committed. And I talked to some of those folks, and I talked to some sheriff's deputies, and I talked to some police officers who were involved in actually taking those guns at the behest of upper management in New Orleans. The Mayor Dagan, the chief of police, and the hierarchy instructor within the police department. They stole those guns from people, and they put them at risk immediately, because subsequently many of them were victimized by roving gangs of thugs who were going around taking advantage of that. Now, you know, as a cop interested in public safety, I'm not all for folks going around and shooting and blowing the place up and such. I'm not for unrestrained violence, obviously. But this put those folks at risk. And what was it? It was an exigent circumstance that they believed justified in taking those weapons, firearms, some of them not really be qualified as a weapon that I would consider as a police weapon. But nonetheless, they could use them for self-defense and protecting their own property. So when I looked at that, I was amazed at it. And I realized then that there was a person down there who could have stopped that. It was the county sheriff or the parish sheriff in Louisiana. He could have said, "Oh, you know, my oath to support and defend the Constitution of the state of Louisiana, the state of the United States, prevents me from letting you continue with this." He could have intervened, but it became a political issue. I don't want to get involved. I don't want to do this. So, while these people were motivated very highly and very concern level, I think that it was wrong. And I think that the NDAA can be utilized in the same fashion, a gradual erosion of our due process. And I would encourage you guys to, guys and ladies, to look at that from the perspective of a street cop. We don't need that. Probable cause, due process, good old legwork will solve the crimes. Just give us the opportunity. And here's why I'm up here today. This little guy here, and
Mr. Atkin, in 5 minutes, if you could please
Thank you.
summarize. I know that that picture summarizes it, but
it does for me. What I would ask you to, yes, I understand the deal with resolution, but I would encourage you, find the strength to go further. Take it to the next level, and let's get something in writing, codify it, so that it will send a message to the federal government that we are not going to let our rights and liberties and due process be eroded. Thank you.
Here, here.
do we have any questions for Mr. Atkin?
Yes, ma'am.
Thank you, Mr. Chair. I just wonder, then, just to clarify, you're not saying that the incidents in New Orleans could have been prevented had we not had this bill. You're just saying that this is what could happen on a bigger scale?
Yes, ma'am. That's exactly correct.
Thank you.
Any more questions? Thank you.
Committee. Let me give you a little background. I'm the General Counsel for the Patriot Coalition, and I'm also a member of the legal team of the Intolerable Acts Project. And that is a project where the Patriot Coalition has partnered up with the Oath Keepers to do a national response to the NDAA legislation. I'm one of the members of the legal team on that. I'm an attorney. I've had 15 years plus of litigation experience. Another member of the legal team is Stuart Rhodes, who's a retired paratrooper, a Yale law grad, and his specialty is the application of the law of war to citizens. That's a very thin area of the law. Mr. Rhodes is one of the foremost experts in the country on that. He's also the founder of the Oath Keepers. We spend about 300 plus man-hours investigating and researching this law, and we spend another 200 plus hours in drafting the resolution, a summary of which, or a reduced one of which is what you have before you in essence. We have also developed a very detailed PowerPoint what we have here today, and we're willing to provide that, run anybody through on that, and it goes through this NDAA bill line by line. And let me make some real quick statements. I didn't want to really get into the substance of it, but we've had a couple of witnesses that have not showed up. But let me make some points real quickly. Number one, NDAA is not the authority given to President Bush in 2001. It exponentially expands that authority, exponentially, and that's covered both in my testimony and in this PowerPoint. If you don't understand that, you need to look at that carefully. And we've seen a continuation of that. The Patriot Act expanded the AUMF of 201, and the Military Commission Act expanded. And what we've been trying to do, or what the Congress has been doing, is trying to play catch up to the President. The Presidents have exceeded their authority under AUMF, and Congress eventually passed a law to catch the law up to what they were doing. So that's one of the things that's going on. The other thing that some people want to argue is that the NDAA does not apply to U.S. citizens. It's bogus. It's a lie. In Hamdi, the Supreme Court said the AUMF does apply to U.S. citizens. The same targeting profile that's in the AUMF is in, the identical one is in the NDAA. They incorporated the AUMF profile and then they expanded it. So it does apply to U.S. citizens. If you watch the floor debate of the Senate when they discussed this, as I did, you would have heard Senator Graham say over and over and over again, it applies to U.S. citizens. The terms of that bill itself applies to U.S. citizens. There was a provision put in there by Senator Feinstein that said that the requirement of detention didn't apply to U.S. citizens. That's a very deceptive phraseology, and I can explain that in more detail. But she is one of the congressmen that has a remedial measure right now to correct this problem. And I watched the testimony on that, and she said, the provision I put in NADA is not sufficient to protect the rights of our citizens. It's the best I could do at the time. So in spite of what other people want to say, she, the one that drafted it, says it's not sufficient. It won't work. And again, we do have this PowerPoint. I would encourage you to look at that. Before you can,
Mr. Fry, let me just ask a question. Have you made that PowerPoint available to our committee assistant?
we have not. I mean,
Okay.
well, we can do that, certainly.
Yeah, if you can, the committee assistant can distribute it, so, okay.
And I will make myself available anytime, any place for one or more of you to provide that, to do that, to present.
Thank you.
Before you can properly decide this issue, you have to understand two different things. The first thing is, what is your duty and responsibility as a sworn legislative officer? And the second is, what is the supreme law of the land? Each of you has taken an oath of office in which you have sworn to uphold the Constitution of the United States. The phrase, "I will support the Constitution of the United States," is mandated by Article 6, Clause 3 of the U.S. Constitution. The duty imposed by that oath is an affirmative duty, it's not a passive duty. It's a personal duty, it's not a collective or joint duty. It's not dependent upon another officer in the government or another branch of the government telling you what is constitutional or not constitutional. You may not defer to another's determination, and you must make your own determination and act accordingly. A duty is something that must be carried out, it is not discretionary. Although the Constitution allowed the states to frame their own language for Article 6, the framers wrote the oath for the President. And it states, "I do solemnly swear that I will faithfully execute the office of President of the United States and will do the best of my ability to preserve, protect, and defend the Constitution of the United States."
Mr. Fry, it has been 5 minutes. If you will summarize, please.
Well, the bottom line is that it is your responsibility to make a determination on this, and you have to understand that Constitution. And you have to understand that federal law does not preempt state law. I hear that time and time and time again by legislators. The requirement before a federal law can preempt state law is it has to meet the procedural process of the Constitution, and it has to meet the substantive process of the Constitution. Your affirmative duty is to make that determination on your own. You may not sit and wait until a court makes that determination. It's your responsibility. You are the safeguards of the people's liberty. You're the safeguards by your oath to safeguard the Constitution. You have to make that determination and act accordingly.
Do we have any questions for Mr. Fry? Thank you. And, go ahead.
Thank you, Mr. Chairman. Mr. Fry, you were related to someone, I can't remember, I didn't get the name of the individual that you said was in the language.
Feinstein, Senator Feinstein.
Oh. Thank you. That's all. Thank you, Mr. Chairman.
Thank you, Mr. Fry. Now, one committee, Mr. Atkin, did have written testimony, and it's in your folder. And we also have written testimony by Representative Charles Key from Oklahoma, House of Representatives, Representative Laura Hobo from South Dakota, and Representative Daniel Gordon from Rhode Island. We don't have any opponents or any neutrals, and we do have a couple of extra minutes. And I can see that Ms. Saddler over there with her eyes is telling me, could I please finish a few more words? So please, Ms. Saddler, but keep it brief.
I think you must have evil eyes to see that. I'll try to make this brief. You guys have been so patient with us. But I left off when we were talking about the Missouri Information Analysis Center doing the modern militia movement. And basically what that did is that marginalized those with conservative views. This isn't about being a Democrat or a Republican or conservative. This is about being American. And that's the point I want to make on that. We've talked about NADA. One thing that I did want to read is when we're talking about sections 1021 and 1022 and the language of law for belligerent persons, and it refers to the United States as a battlefield. Basically this violates 4 articles and 7 amendments to the Constitution and Bill of Rights. So how can it be a constitutional law? On February the 10th, 1936, the Nazi Reichstag passed the Gestapo law, which allowed the following, or included the following paragraph. Neither the instructions nor the affairs of the Gestapo will be open for review by the administrative courts. This meant the Gestapo was now above the law, and there would be no legal civil court appeal regarding anything it did. Indeed, the Gestapo became a law unto itself. It was entirely possible for someone to be arrested, interrogated, and sent to a concentration camp for incarceration, a summary execution with outside legal procedure. Does this sound familiar? I'm not a conspiracy theorist. I'm a Republican precinct committee woman. I've abided the law all my life. These are the things that bother me. The other things that, and I do have copies of this for you. The National Preparedness Act was another one coming. The Grounds and Protective Building and Grounds Act is another one we need to take a look at. And the 2 upcoming legislations are the Enemy Expatriation Acts, which actually gives them the right to take away our citizenship, and the See Something, Say Something Act, which is right out of Nazi Germany. So those are the only things that I have to say, and I hope that what you do is you consider what we say today. Don't think of it as political. Don't think of it as military. Just please look at our testimony as an American citizen.
Mrs. Saddler, I noticed you have some written material.
Yes.
Maybe you can make that available to our assistant.
Richard, do you have, I thought we had this already prepared for them to give them a copy of mine. Do we not have any? Oh, okay. I do have one now. I have an extra copy.
Just anyone here that has some written material, if you make it available to our committee assistant, we can have the material when we work this bill, which we'll probably do it tomorrow. And I want to make sure that the committee has all the information so they can make a logical decision.
I appreciate that, and I will get an opportunity. Thank you.
Thank you. We do. We do have one question.
Thank you, Mr. Chairman. And Ms. Saddler, if you wouldn't mind going back just for a moment on the last part of your testimony. This is after 2009, and you were discussing other acts that have recently been, produced and effective. You said National Preparedness Act. What was the timing on that act?
That was 2012. That just happened this year.
Okay, and there was an act that followed that, but I didn't get a chance to.
Right, and then it's the Federal Protected Building and Grounds Act, and what that does is actually expand the authority of the Secret Service. Especially, I call it the anti-protester law, that if we as American citizens want to protest, we better make sure that we're not in the vicinity of someone that's under the guard of the Selective Service, or the Secret Service. And the Secret Service used to be protective of people who were in the service of the U.S. But now the president can just sign a memo saying that he wants you protected or me protected, whoever he wants protected. And so if, let's say that you're protected by the President of the United States and you happen to be at the Super Bowl and there's an outburst of any kind, then basically those people can be arrested and detained and without due process. So that's the buildings and grounds.
Okay.
It was S347 was the number on that one.
And then the Act, I presume is also 2012.
Right. These are the 2 upcoming. Is the Enemy Expatriation Act, and then the See Something, Say Something, which is that's the one I consider to be right out of 1934 Germany, because basically they're going to reward people for telling on each other.
Thank you very much for your
Thank you.
Ms. Saddler, I see two more questions. I have representative.
All right, we're gonna work on this still tomorrow, we're not?
Yes.
I'll wait until tomorrow.
And we have Representative Myers.
Thank you, Mr. Chairman. I was just wondering, this resolution, you only deal with the NDAA from this last December, but it sounds like these are concerns you have stemming all the way back to the original Patriot Act in 2001.
Yes.
Why does this resolution only talk about the NDAA this last December?
Because it's the most egregious. Prior to this, yes, the NDAA has happened on a yearly basis, but never before has the terminologies or the section 1021 and 1022 been involved. It was strictly to fund the military. That's all it was for. That's all the NDAA has been in the past. But now they have slipped some secret things in there, and that's one thing as as lawmakers that we have to take a look at is what's hidden in these bills. We've never had bills go through like this, where you have to dig down deep, and thank goodness for Mr. Fry's constitutional background and Stuart Rhodes with this military law, understanding that, because they can literally pick these things out, and it does take them hours of research to do that, but that's what the difference is.
So the authorization for use of military force from 2001, you're fine with?
No.
Thank you, Mr. Chairman.
No, I'm not fine with that, but as far as the ins and outs, that's a little bit more detailed than probably what we need to go into today. Thank you.
And committee, do we have any more questions? Thank you, Ms. Saddler. And again, any member that made some presentations today, if you have some written material, please give it to the assistant, the committee assistant.
Yes, sir.
Mr. Fry.
I'd like to make a formal request for notice of any further action on this resolution.
We don't have such a process in the legislature. I tell you what's going to happen, okay, so everybody understands. Tomorrow, we're going to be having a meeting at 1 o'clock where this is going to be addressed. And it should be the wisdom of the committee as to what is going to happen, if any action. And so we're going to be working the bill. Whether the bill progresses to the House floor is at the wisdom of the committee. That's why it's important to have all the material so the committee can make the proper decision. Then, of course, once it goes to the House floor, it is debated there, and the House determines if it will pass or not. But anyway, I just want to explain the process.
Do you plan to work the bill tomorrow?
That's correct.
And will it be in here at 1?
Yeah, it's this same room. Anyway, Representative.
I'm sorry, Mr. Chairman, this is not a concurrent resolution, this is a House resolution.
Yeah, it's a House resolution.
Thank you.
Anyway, do we have any members of the committee or any members of the audience that have anything else to add for the good of the committee? Well, I'm going to go ahead and adjourn the meeting, and thank you everybody for the testimony.